Hello and welcome. My name is Jeremy Brand. I'm a partner with Brand Partners Commercial Lawyers. I'm a solicitor and I'm an accredited specialist in commercial law and also in commercial litigation. I've got 30 years of experience. I've pretty much seen it all, and I'm here to help. So how can I help? Well, I'd like to give you insight into the legal process and maybe give you some of the tools that you need to arm yourself when dealing with lawyers. So the first thing I want to talk about is, how do I engage a lawyer? How do I find the perfect lawyer for me? Now, this is really complex because I had trouble with this myself. If I need a lawyer, I sometimes have to think pretty hard, who am I going to go to? And especially in certain areas. If it's difficult for a lawyer, it can be even more difficult for a client. So let's talk my philosophy, how I would approach it. And the first thing I would say is forget the marketing hype. In fact, if we're talking, for instance, litigation, if I went to a lawyer and that lawyer had marketing splurge about how many cases they'd run and how many cases they'd run and how many they'd won and all of that stuff, right? Unless it was in a particular area where I might be a bit forgiving, for instance, personal injuries, I'd be running out the door. I'd grab my coat, my hat, my umbrella, I'd be straight out the door and down the stairs, quickly have a coffee and think, thank goodness I got out of there. Why do I say that? Because it's not about marketing, right? It's just not about marketing. And if it is about marketing, then the best type of marketing is, I don't run cases, I get them resolved. Because guess who pays for the case that was won or lost? You do. You do. If we talk about a Supreme Court case or county court case, how much does it cost to run that case? 250, 300,000, 400,000? What does it cost? It costs a lot. It comes out of your pocket. Surely the best marketing of all is, I resolve my cases overwhelmingly. So there's the philosophy of Jeremy. Tell me that you run lots of cases, you win all these cases, I'm going to kind of glaze over. What would I look for in a lawyer? Well, obviously I'm looking for specialty. I'm looking for somebody who is a specialist in their area, or at least has a lot of experience. And that can be difficult to judge because so easy as, oh yeah, I've got all the experience in the world. So independent qualifications in particular areas, corporate qualifications, specialization, so forth, I would look for that. What else would I say? Well, I'd want to know what they're going to charge me. And I'd want to most particularly know, what do they think it's going to cost to run my matter? Now, if it's a commercial matter, drafting a document, how much do you think it will cost? I have to be cautious here because whether it's commercial or litigation, what the solicitor has to do is inform you of his or her estimate of the cost to do the work. Sometimes you get fixed fees, sometimes you won't. The issue here to me is, well, how much are you going to cost to the end? To the end. So let me explain that in the context of litigation. You can see that's me there. And let me pop in here. Any advice I give is not advice. It's my general musings. If it helps you, I'm really pleased. But you can't rely on it because you're not my client. You need to get your own solicitor and you need to rely on what your solicitor tells you. So, however, coming back to it, I would want to know, in the case of litigation, and what's required by law to be given to you, the client, up front early on, is my estimate for your case all the way to the end. This is important. So listen up now, because if you take nothing from this other than what I'm about to say, I've given you a lot. You go and see a lawyer. You say, I've got a case. It could be an estates case. It could be commercial case. It could be some other type case. I've got a case. What do you think? The lawyer says, well, I think you've got a pretty good case here. You say, well, how much is it going to cost me? The real question is, how much is it going to cost me, assuming it's hard fought and it goes all the way to the end of trial? And I'm telling you now, if you've got a hard fought case in the Supreme Court, even for a smaller matter, not for a huge multi-million dollar, 10, 20, 30, $100 million case, you've got a case, a serious case for $500,000 with a lot of complexity, interpreters and so on. I'll give you an example shortly. You're easily going to look at $250,000, $300,000, $350,000. I can say that without even knowing what the case is about. Now, that should give most people pause for thought.
Now, I like to invite my clients to think of litigation like you might a locomotive, a train. And the train, you get on it and you get off it at the station. And the station is the court. And if you try and get off the train while it's traveling to the station, you can get hurt. I'll explain. You issue a legal proceeding, not in VCAT, in a court, Supreme Court, County Court, Magistrates Court. You give it a go, and after you've got halfway through, you're thinking, I'm not sure I should have done this. Costing a lot of money, there's risk involved. I think I want to stop. You can't just stop. You can't just stop. Well, you can just stop, but then you end up paying the cost of the other person because you started this proceeding. You've incurred all of this cost, but you've made them incur costs. So either you can do a deal and you get off the locomotive without injuring yourself, or you can't do a deal and you have to pay their costs. And people are faced with this as a real issue. So coming back to it, you have to know what it's going to cost all the way to the end, not to the beginning of trial, to the end of trial, which means you need an estimate for how long it's going to take. I can tell you, I have had people come through my door and they've come through and they've been given estimates. They're involved in litigation already. They've been referred to me through one means or another. They're unhappy. And I look at their position and I say, can't help you. And the reason I can't help you is because I'm not going to add value. Now, I'm going to change some of the facts. I'm going to give a couple of examples. I don't want to identify anybody. I recently had a person come and see me. They were involved in litigation. They were very unhappy because it cost quite a lot of money. They asserted, this person asserted that they had been given a quote which was much lower than the estimate. So I had a look at it and immediately quickly formed the view that the cost to run this proceeding, for me to take it over and run it, would be far higher than the potential value to this client. And by value, I don't just mean whether he was going to win or not going to win. I'm talking about including the risk of loss. So if you're chasing $300,000 as an example, and let's say you're doing it in the county court, what's it going to cost to chase that? Let's say that you're told it's going to cost $100,000. Then you have to take into account, well, what's the cost of losing? That could be $80,000. I mean, generally less than what you pay for your own lawyers, but a lot. But that $100,000 could be $150,000 or could be $200,000. In the case of the gentleman who came to see me, even though his claim was for a number of hundreds of thousands of dollars, there was high risk, in my view. It was complex. He'd already spent a lot of money. I couldn't add value. I told him I wouldn't take it on. Now, in the end, he came to me and we resolved the matter rather than running it. I wouldn't say it was a happy outcome, but I can tell you this, he did not have the wherewithal, nor did he want to pursue what was a risky case all the way to the station. He wanted to get off the locomotive. So how do you avoid getting on it? Well, you avoid it by making sure, well, by having the person who's advising you give you a realistic estimate of what it could cost. I just said realistic. And then, you know what went straight to the back of my mind? A pessimistic estimate. Don't tell me about how I could settle early or anything else. Sure, you could settle early. You could settle at mediation. You could settle the day after you issue proceedings. But tell me what, if that doesn't come to pass, and I go all the way to the end, to the station, how much could that cost me? That's what you need to know. Look, there are so many examples of this that have come through my door that it's quite remarkable. It's a difficult area for the legal practitioner, because often when we see you, you tell us a bit of the story, but not all the story. You might not even know the whole story. You don't know what the other side might say. They often, when you get involved in litigation, the other side start making allegations and assertions which you don't even anticipate. That's why I can tell you, walk through my door with a Supreme Court matter, I'm immediately going to be thinking, you're up for a lot of money, a lot of money. So it's got to be worth it, and you've got to be prepared to go the whole way. And let me just tell you as an aside, I have people who come and see me, and I look at their cases, and I say, I think it's going to cost $300,000 or $400,000 if it goes all the way. And they virtually run out the door. They run out the door. And they think to themselves, no doubt, I'm not going to go to a lawyer who charges that kind of money. It's ridiculous. And I get that. And I'm happy for them. I don't want the headache, and they don't want the cost. However, I have had that exact situation, and the same person come back to me 6 months later with a very bad story that it's cost significantly more than was estimated. I'm talking tens and tens and tens of thousands, and they're not even a quarter of the way through. I've taken over a matter which was in exactly that position, where I'd seen the person, they left, they got a lower quote, whatever, turn up. And in that case, the matter ran for weeks. It ran for weeks because everything was in dispute. Everything was in dispute. So you have to be realistic, and you have to, most importantly, have a realistic or even pessimistic solicitor who gives you an estimate to the very end. You know, there's all right, so that's enough for the moment. When we come back, I will talk about what's required to form a contract with a solicitor. Perhaps delve into the conundrum of hourly rates and budgets. And if we get time, have a chat about what is not a lot of money to sue it for. I mean, that's a really difficult one. And so I hope you've enjoyed this, this session, and I'll see you next time. Thanks.